Good morning, everyone. Thank you so much for joining us today. My name is Scott Thompson. I am an associate director in the Ole Miss Alumni Association. And if you've not been to one of these before, these series are called Upfront. They are virtual talks with experts. And what we do is out of the alumni office, we work with the various schools across campus. And we take our faculty and staff who are experts in their fields, and they talk about what they know about. And one of the pleasures that I have in the alumni office is I get to work with the School of Law. And so today's speaker is brought to us by the School of Law. A lot of you know him, have had him, and know the success that he's had out of the class in the classroom with Moot Court. And I'll tell you just a little bit about him. And I'm not going to do his bio the justice that it deserves, but Dr. Case came to us. He has a bachelor's and a JD, both from the University of Mississippi. Went to Columbia and got his LLM, and then he obtained a PhD from Vanderbilt. He clerked in the Fifth Circuit Court of Appeals and in the Mississippi Southern District Court. He practiced law for several years, and he was on faculty at the University of Memphis School of Law before joining our law school in 2007. The focus of his legal scholarship is environmental regulation and management, which has served him very well as a Moot Court coach. He is currently putting his fourth child through the University of Mississippi. This one, if he follows in footsteps, this may not be the only degree he gets from the University of Mississippi. And again, I've probably skipped a whole lot that deserves more recognition, but I believe that David Case would agree that his children are the highlight of his bio. So with that, I'm going to go ahead and turn it over to you. I will let everybody know that you are muted right now. If you have a question, feel free to unmute your microphone and ask, or you can type your question into the chat, and I'll be happy to relay that to Professor Case. So it's all yours.
Well, hello, everyone. This is not as weird as it might be because I've been teaching remotely for the last 3 terms at Ole Miss. So we all started teaching remotely in the spring when the pandemic really hit first, and then I taught over the summer term, and now the fall term I'm teaching remotely. So I'm very used to Zoom, and I see some names of people out there that I kind of want to call on them and start asking questions, Lori, Allison, Taylor, but I guess that's not what this is for. So I need to remember this isn't a class. This is something different. So I actually have some PowerPoint slides, not because I'm trying to teach a class, but because they kind of keep me focused and on a path and prevent me from letting the absent-minded professor in me take over completely. So I want to walk through these slides. There's only 10 of them to kind of just make a basic presentation here about Moot Court and its role in education and law school. But then I definitely want to answer questions if people want to ask questions about this. So let me see if I can do this correctly. Okay, and so that's not what I want. Okay, so I hope that everybody can see these slides. Thanks, Scott. So the reason that I'm talking about Moot Court and legal education, and when I was asked to do this, the reason was because, please move the window away from the shared application. So I think I've done that. I recently wrote an article about my experiences in coaching moot court over the last 20 years that was published in the Mississippi Law Journal. So I had a number of different motivations for writing a law review article on this topic, because this is not my normal area of scholarship. Like Scott said, I typically publish in environmental regulation and management. And I'm an environmental law professor and administrative law professor at the Ole Miss Law School. But I wanted to capture my experiences from the last 20 years in working with law students, both at the University of Memphis and for the last 13 years at the University of Mississippi. So the article is called "A Pedagogical Rationale for the Law Professor's Moot Court Coach." And it's published in volume 89 of the Mississippi Law Journal, which just came out earlier this year. So I didn't want to just write about the fact that we won a lot of moot court championships while we were competing in the National Environmental Law Moot Court competition. I wanted to write an article that was directed at other law professors, full-time law faculty, to try to persuade full-time law faculty that devoting a portion of a law professor's time toward coaching moot court teams and working with students in this area was a very good use of a law professor's talent and time. And also it's a very meaningful experience for the professor and not just the students. And so that was my primary drive for this article. Because I taught environmental law and have taught environmental law for so long, I was approached when I first started as a law professor in 2001 at the University of Memphis, where my first job on a law school faculty was. Because I was the environmental law professor, some students approached me and asked me if I would help them get ready for the upcoming National Environmental Law Moot Court competition, which is held every year at Pace University School of Law in White Plains, New York. Now, I'd never heard of it. I wasn't particularly involved in moot court when I was a law student. We did have to satisfy the moot court requirements as an Ole Miss law student. So I did a mock trial and a mock appellate argument. But I wasn't on the moot court board and didn't get involved in moot court competitions in law school. And so it wasn't something that I'd ever really thought about as doing as a professor. I thought, law professors spent their time in classrooms and they spent their times doing research and scholarship. And so it was kind of a surprise to me that students were asking me to do something like that. But also I was a brand new untenured professor at the law school. And so I was very nervous. And so I had this idea that, well, when students ask the environmental law professor to help them get ready for an environmental law moot court competition, I think I'm supposed to say yes to that, even though I have no idea what you do in a moot court competition or any idea of how you would get ready for something like that. But I said yes because I was afraid to say no. So that's what kind of started me off on this adventure. And there was a big learning curve for me that a lot of it, but not all of it, came while I was at Memphis. But the competition itself, again, it's been around since 1989. It's the most well-known environmental law moot in the world, and I do mean that literally. There are other environmental moots in the U.S. and in other places in the world, but the National Environmental Law Moot Court Competition at PACE is considered to be it. But the thing is, it's also one of the largest, most competitive moot court competitions in the country of any kind. So the fact that it's about environmental law itself doesn't have a lot to do with why a lot of law schools are very interested in the PACE competition. It's known as one of the more competitive, one of the more difficult, challenging moot court competitions. And so that's why in a typical year, between 70 and 75 law schools will show up for the competition. That means over 200 individual law students are there to compete. One year, PACE forgot to do their normal cutoff, and 87 law schools showed up that year, and they had us doing rounds in broom closets. I saw parts of that campus that I'd never seen before that year because they pretty much ran out of room, and it's a pretty big campus. So they build themselves as the largest inter-school competition of any kind under one roof in the world. And so it's, if you like intercollegiate competition, then you like the National Environmental Law Moot Court Competition. So Scott knows this about me, and some of you out there know this about me, but for the first 40 years of my life, my father was a college football coach. And I never seriously considered making that my profession growing up, although I was very, very much immersed in college football and college football coaching culture. But I was always going to go in a different direction, I thought. Well, the first time I went to PACE and saw what an intercollegiate moot court competition was, I think it affected me because I was somehow predisposed to having that kind of a competition affect me. And so whatever coaching genes I may have inherited from my father, they were triggered by the experience of seeing the competition for the first time. And so I talked with a lot of people there and got a lot of advice about moot court coaching and preparing for this competition, things that I didn't know that weren't, necessarily intuitive for me. And so I kind of returned with the idea that I was going to up my game, because what's the point of going to a competition if you're not actually trying to win the competition? So that early experience at PACE, the first competition I saw, I think really affected me. So I coached teams at this competition over an 18-year span. For the first 6 years at Memphis and for all the time from 2009 on at Ole Miss Law. After 10 years of doing it, I was ready to retire because it is an incredible grind. You put a lot of effort and time, particularly when you go at it the way we went at it. It's hundreds and hundreds of hours of work over a 5-month span. So, after 10 years of doing it, I was feeling like, well, a decade of this is enough. And I'm probably ready to let this go and move on to different things. And that year that I was having that internal conversation with myself, we won the championship in 2011. And I will say the effect of that at Ole Miss Law was pretty remarkable. The moot court board at Ole Miss Law was very excited. And so suddenly I felt I had a tiger by the tail and I couldn't let go of it. So I didn't stop after the 2011 year because I felt like I couldn't. So we went on from there, and we won 5 championships at the PACE competition over a 6-year span. So we won in 11, 12, 14, 15, and 16. So you'll see on this slide that, you know, I had a 2013 team that got eliminated in the quarterfinals. That was the one team in that 6-year span that didn't win the championship. And Scott, if anybody asks a question in the chat about what happened in 2013, I'm not going to answer that question. I don't want to talk about it. I'm still pretty angry because that was one of the better teams that I ever took to the competition, and they should be between the 2012 and the 2014 on this slide, but really awful debacle based on the judges occurred in the quarterfinal round, and I'm not over it. But 5 out of 6 years of winning the national championship at the competition is pretty good. And so it's not that I am sad about it, but you often regret some of the teams that you take up to a competition like this that you know are every bit as good as teams that won and they didn't get the opportunity to share the same experience and joy. But this slide represents a lot of really hard work and a lot of really great success by students that put in incredible amounts of work and then performed at an incredibly high level. And so I am proud of every single team I ever worked with over this span. Because it's hard to go to a competition like this and make it out of the preliminary rounds and qualify for the quarterfinals. So this is a lot of success and a lot of incredibly difficult, challenging work. So I have a lot of pride in what is actually reflected on this slide. But getting back to the article, why did I write it? What is it that motivated me to do this? Well, part of it is the whole, I'm an Ole Miss alum. I graduated from Ole Miss undergrad. I graduated from the Ole Miss Law School. And as I tell my students all the time, well, the university is not just where I work and where I get a paycheck. The University of Mississippi is my alma mater, and I'm very proud to be an Ole Miss alum. And so when Ole Miss does very, very well at something, well, I think there ought to be a written record of it. So I wanted to write this article and publish it in the Mississippi Law Journal because I want people to remember that we did it. I want people to remember that Ole Miss Law was very, very successful over the years at this. And then second, the idea was that, well, I've decided to retire from Moot court coaching because, again, it is an incredible grind. And so I decided at some point, and I had a health issue that helped me decide this, that it may be time for me to kind of hang the gloves up. But I wanted to write down exactly how it was that we accomplished what we accomplished. And so the article really, I say it's the blueprints for how we did it. And that really is true. It's just the blueprints to really describe what we did and how we did it in the detail in which we performed that work. It's really not possible to do that in a law review article. So it really is an outline of how we accomplished what we accomplished. but the article really is about something a lot more important than winning national moot court competitions. It's really about the educational experience. And that's what's really important here. That's what really matters. And that's actually what this article is about. It's the incredible educational experience that law students get through participating in this moot court process. And so that happened every year, not just the 5 years that we actually won the competition. And so that's what I'm most proud of, the opportunity for me to have been such an important part of these students' educational experiences. And so that's really what I'm trying to convey in the article, and why I think the article was actually worth writing. I mean, I don't mind writing an article that says, hey, I coached 5 teams that won national championships, because, hey, I did that, and that's really cool. I didn't do it alone. I had a heck of a lot of help, and the students should be getting the lion's share of the credit for that. But, you know, again, that is part of the motivation to write it. But the real motivation is the educational experience here, I think matters a great deal. And that's what I wanted to talk about the most. So the theme of the article is that for the law professor, for the faculty moot court coach, teaching is the most important part of this. And so if your goal is winning, if your goal is that, well, it's competition, so I'm coaching because I want to win things, well, that's not the right way to approach it, because the educational goals in this educational experience are far more important than winning a competition. But what I learned over 18 years is that, well, but if you do have the goal to win, and I really did have the goal to win, because again, the whole coaching gene thing, with my father being a college football coach for as long as he was, those things aren't mutually exclusive. I found that the more intensely that I focused on the fundamentals of legal education in this moot court process, the more likely the teams were going to be successful at the competition. So these goals of educational excellence really do mesh very well with the goals of competitive excellence. So I really do think that focusing on your role as a teacher, as a faculty moot court coach, is the best way to approach if your desire also is winning is better than losing. And so the article really does try to emphasize that more than anything else. So I approach moot court coaching pretty much the same way that I focus my approach on teaching first-year law students in the substantive first-year courses that I teach. And so for the entirety of my career as a law professor, this is my 20th year as a full-time law professor, I always teach first-year law school courses, because it's my favorite thing to do as a law professor is teach first-year courses. You know, I was hired by Memphis and by Ole Miss to be an environmental law professor, which is not a first-year course. So it is my primary teaching area and research and scholarship area. But I think first-year courses are the most fun you can have in law school. Now, I'm not convinced that all of my students agree with that, but I agree with it because it's the most fun for me. And so I teach contracts and property and civil procedure pretty much every year. So I spend so much time teaching first-year law students and focusing on the fundamentals of legal analysis in those first year courses that eventually my approach to coaching moot court teams just morphed into my approach to teaching a first year law school course. In both endeavors, I'm trying to teach the students how to achieve excellent execution of the basic fundamentals of legal analysis. And so I'm pretty obsessive about it, both in a first year course and in moot court coaching. And so what I found is that that approach is extremely successful for moot court, that if that's your focus, basic execution of the fundamentals of legal analysis, moot court judges respond to that extremely well. And I know that there's a number of my former students who are listening to this right now. I'm looking at one of my former team members right now because I can see her. Hi, Caroline. And so they can testify if there's a need to this. But I'm pretty obsessive about legal analysis and how you do it. And with me, there's only one way. There's not alternative ways to execute fundamental legal analysis. So I have pretty strict rules and pretty strict approaches to it. And I'm convinced that it works in a classroom, but I'm very convinced by now that it works in moot court competitions, that judges, not 100%, but I would say in the very high 90 percentile, really do respond to students during the competition, focusing obsessively on some specific rule of law and application of that rule of law as precisely as possible to the specific facts of whatever the problem is. So the approach works for moot court coaching, I think, quite well. Another thing my article tries to explain, and this is why did I spend 20 years with moot court coaching as a hobby, because it's not a requirement of my job. It's not like I'm, getting extra compensation for putting these hundreds and hundreds of hours of work into this during an academic year. But it's not just about teaching legal skills. It's not just about teaching oral advocacy, although moot court is excellent as a form of experiential learning and training students in critical lawyering skills like legal research, legal writing, legal analysis, critical thinking, oral advocacy. Moot court competition is excellent as a vehicle for teaching those things. But what I found, and this was not just for the students, this was also for me as an environmental law professor, moot court is an excellent educational vehicle for teaching and learning substantive law. And so here, because it's obviously an environmental law competition, the substantive law is environmental. But I learned as much, sometimes more, than the students did in this process about my area of teaching that I never would have had to confront, that I never would have been exposed to were I not coaching moot court teams in this competition. And so the students are forced in this process to immerse themselves in the relevant areas of law that apply to the competition problem for 5 months. They live with this law and they've got to go into it incredibly deeply to develop the comprehensive knowledge and the deep understanding of the law that's necessary to answer any conceivable question that can be asked about the problem. And so you learn the law at a very, very deep level when you have to confront this, which again, I think makes moot court an excellent teaching tool, because you are learning at so many different levels simultaneously. It's substantive learning, it's skills training, it's a critical lawyering skill training. It's really amazing the deep level of learning that occurs over the course of participating in and preparing for a moot court competition. So I talk about the fact that moot court is a superior form of learning to basic traditional classroom learning in law school in the article for a number of different reasons. One of the things I like about moot court is it's a legal writing competition as much as it is an oral advocacy competition. And so the more work students do in law school in developing and working on their writing ability, the better. And so I was fortunate enough because what you find out in moot court competition is that if you don't have a competitive brief, you will not do well at the competition. On that slide with all the team accomplishments over the years, there's a couple of years that aren't on that slide. A couple of times I took teams to the competition where they did not advance to the elimination round. So they didn't make it out of the preliminaries. And both times it wasn't because those teams didn't put the work in. Those teams absolutely put the same level of work in that teams that won the competition did. Both times we didn't advance, it was because the brief was a train wreck and scored very, very badly. And so once you understand that about moot court competitions, that if your goal is to be successful competitively, then the brief has to be competitive to have a chance for that to happen. And so it's, in that sense, very much a writing competition, not just an oral advocacy competition. And I was very fortunate to get to watch 4 of my teams win Best Brief Awards. And the best part about that was always, I couldn't help the teams with the brief. The competition rules forbid the students getting outside help. They have to do all the research and writing and work on the brief themselves. And so when they won awards for the brief, that was 100% the students. That had nothing to do with me, except all the threats I made before they started work on the brief about how important the brief was and how incredibly disappointed I was going to be if I read the brief after they submitted it, and I would be able to tell that it was non-competitive. So I'm not going to go into deep detail about the threats that I may or may not have made. I do discuss them somewhat generally in the article, but that was my contribution to the brief writing process. Was I was the incentive for the brief not to fall below the floor of competitive. And so it seemed to work because even for years where the team didn't win a Best Brief Award, they produced some incredibly outstanding briefs. And so I was always really proud of that because that work was their work. I wasn't able to contribute at all to the quality of that work. The other thing about moot court that I think is a superior form of learning in law school to just traditional classroom learning, it's a research challenge. The students are essentially doing legal research related to the problem for 5 months, because the research doesn't stop after they write the brief. They've got to go forward and research all the way through the preparing of the oral arguments, often because their faculty coaches on the bench during practice rounds yelling about how you don't have any support for that and you better get some support for it, because I'm not going to let you make an argument if you don't have support for it. Also, Moot Court allows students to work on the skill of teamwork, which is really under appreciated, I think, in law school as to how important teamwork for lawyers is in the real world of practice. It's very normal to be working as a team in litigation and in working on problems for clients. And so Moot Court offers students the opportunity to develop those skills, often through trial and error, often through trying to deal with teammates who may be challenges to deal with. And so it's a great educational experience in Moot Court that you don't get in the classroom and that you don't get in many instances in law school outside of some clinic experiences. And so I really appreciated that aspect of it. Moot Court is a problem-based approach to learning because the competition problem, the moment it gets released, it's the student's problem. They own it, and therefore they have a greatly increased role and responsibility in the educational process. Most of their law that they're going to be applying and learning and trying to understand, they've got to go out and find it. Because the faculty coach will tell them, hey, that's not my job. I'm not the lawyer here. You're the lawyer here. You've got to go and answer these questions and figure it out. I'm just the person you've got to check with as to whether your answer is going to pass muster or not. But the work belongs to you. The responsibility belongs to you. And so students are active participants in their education, not passive participants in their education, and therefore they're more invested in it. And the value of the educational experience then is much, much greater. And so it's really impressive how much the students own the process as we go through it. Then Moot Court offers students the opportunity to get something that I hope they valued, but sometimes they may value it more than in other times. But they get hundreds of hours of my undivided individual attention, which is not something that happens in a classroom. And so they get continual, constant, individualized feedback from the faculty coach towards developing their understanding of the law and their skills and legal analysis and advocacy. And sometimes I would tell students, back when I charged by the hour for what I did as a lawyer, and my rates would get up into the ridiculous sometimes. So if I'm charging $250 or $300 or $350 or $400 an hour for my time, think about how much of that you're getting here, where I'm spending all of this time, to help you, to give you feedback, to work with you on this. This is fairly valuable as an educational experience. And so that's the part of Moot Court coaching that I really enjoyed the most, is I got the opportunity to work individually with specific law students and give them far more individual attention than I'm used to having the opportunity to do. And then this is the last slide. So the goal in preparing for the competition, the reason that we would have the chance to win when we showed up year in and year out, is because I learned in those early years of going to the PACE competition in White Plains that if you weren't putting in at least 25 full practice rounds in advance of the competition, you were not going to be at the level of the law schools that would show up, and that's the amount of work that they had put in. So just to have the opportunity to compete and win, you had to try to get up to that level. So 25 to 35 full practice rounds with the PACE competition is three-sided. So there are always three parties, meaning that at this competition, you're not just competing against one team at a time, you're always competing against two teams at a time. It's one of the things that makes the PACE competition harder. Everything is three-sided. And so it's three arguments in a round. The rounds are longer, 90 minutes. Again, you've got two different teams shooting their bullets at you that you have to respond to. And so that makes for a very hard practice round where the students have to be all three sides in a practice because I wouldn't do it any other way. And so they had to argue the full round. They're switching their sides. First, they're arguing one position, and then they're arguing exactly the opposite of what they just argued. And I'm peppering them with questions. My co-coach, Stephanie Otts, who worked with me for all my teams from Ole Miss, is a far more relentless questioner than I was because I was sitting back and doing more evaluation of how the students were doing. And Professor Otts was just coming at them full bore all the time. And so that's difficult to live through 35 full practice rounds like that in advance, the 5 or 6 weeks in advance of the competition in February. So, and so that many repetitions, I mean, so again, each practice is essentially a 3-hour class. And so that many classes with the same professor basically makes that the most rigorous classroom experience any of these students could possibly want to have. And so it ends up being a 25 to 35 class Socratic dialogue on the same problem with the same students. And of course, the students develop the understanding that they know what questions are coming. They know that this judge ripped that answer to shreds the last time that they gave that answer. So they're going to have to come up with a different answer, a better answer. They're going to have to deal with the vulnerabilities and weaknesses in their arguments in the law as they're arguing it in their support. And so the students are forced to evolve and to improve and to become better because the Socratic dialogue in this classroom setting doesn't change. It doesn't go away. It keeps happening. And so the opportunity for education and learning and improvement, it really is a law school class that's heavily Socratic on steroids. And so the entire process becomes what I call a master class in advocacy and legal analysis for the students who are participating in it. So that's, primarily why I think the educational experience that the students are getting here is so superior to anything else they could be getting in law school. All right, so I've come to the end of my slides. So now the chances of me going off on a more of a tangent and being even more random are much higher. But if there are questions that anybody wants to throw in my way, I'm happy to start answering them.
David, we had a question come in from one of our alums, Ben Griffith. And
Ben. Hey, Ben.
So, Ben's question has to deal with expenses. I mean, these competitions aren't down the street at MC or across the border at Alabama School of Law. They're all over the nation, and even we've gone outside the nation and have participated in won worldwide competitions.
Absolutely.
So, how are student travel expenses for moot court competitions defrayed, and is support provided by such external sources as Lamar Order or the State Bar Association or law alumni?
The answer to a lot of those questions is yes. But there's a budget that the Moot Court Board has, and the Moot Court Board's budget comes from different sources. And the law school has been, really supportive of trying to keep the Moot Court Board's budget and other advocacy boards as well, because the Moot Court Board's not the only game in town at the law school. We've got the negotiation board, we've got the trial advocacy board, which is amazing to me. We only had the Moot Court Board when I was a student, and now we've got 3 different advocacy boards. But there's a budget that the board has. It gets funded from different sources. So I wish Matthew Hall was here because he would be able to answer this far better than me. So that means that the number of competitions that the board can support in any one year is not unlimited, but we are able to send a good many teams over the course of an academic year to competitions. And so there's a process where they decide at the beginning of the year, which one. Hence Suzette is telling everybody, this is how it gets funded, of course. Does the Lamar Order support some of this? Yes, I think certainly some of the money that finds its way into the Moot Court budget is due to Lamar Order support. Individual donations from law firms, that want to support moot court activities, or individual lawyers that want to support moot court activities, make their way into the budget. PACE was one of the more expensive competitions just because it's in New York. I know we do competitions in Texas and Los Angeles and Florida, and Scott said the space law program has, their competitions are international as well as domestic, and we have literally won world championships in the space law moot court, although their funding is outside of what the Moot Court Board's funding is. They're their own independent program. But yeah, I mean, these competitions aren't cheap. But again, the law school and the law school administration has been very supportive of the advocacy programs at the law school, and there is fundraising that is kind of tied to it. And like Suzette said, if you're looking for ideas of how to support the law school financially, directing your support towards these boards and the advocacy programs themselves is a great way to support the law students and support this kind of education, because it really is incredibly valuable, but it's certainly far more expensive than classroom, teaching, because the number of students who are doing this is obviously quite a bit smaller.
And I'll remind folks that if you would like to ask a question, feel free to unmute your mic and ask, or you can type into the chat and I'll relay it to Professor Case. And while you're pondering what you might want to ask, I've got a question for you. We fall back on we talk about your dad being a D1 football coach. One thing that I think is very common amongst athletes and coaches is they're superstitious. Do you have any superstitions that you participate in, either in preparation for your competitions or at competition?
Well, yes, even though I don't believe in things like superstition, and I'm not a supernatural believer kind of person. I still would do things exactly a particular way because that's just how we do it. And I want to do it different because it might mess everything up. So, for example, and this comes from my father, who coached for 40 years at, great places like Ole Miss and Vanderbilt, and then really awful places like Alabama and LSU. And that's another thing I don't want to talk about. But he didn't believe in scrimmages. He didn't like it. He only believed in live games. When the lights are on, the lights are on. If it's not a real game, he'd rather just practice because he thinks practices are way more valuable than scrimmages. And so I was kind of like that. I didn't do dress rehearsals. I didn't want us to dress up and pretend like we were actually at the competition because we would all know good and well we're not. And so let's just practice. Our time is better spent just, working as opposed to doing a thing that to me was just a distraction and a waste of time. And I get that from my father. But another thing that I did at the competitions themselves is the competition would be over 3 days. So Thursday, Friday, and Saturday. So Thursday were the first 2 preliminary rounds. And then Friday morning would be the third and last preliminary round. Then after that, they would make the cut down from the 75 schools to the 27 that would be in the quarterfinals. And so the Friday afternoon round was the quarterfinal round. Then Saturday would be then the semifinal round in the morning and the final round in the afternoon. So I used to wear sweater vests all the time. It was part of my uniform. And so I would wear a sweater vest every day. But on Saturdays, when we obviously were there because we had made it to the semifinals, that was Tiger Woods' Sunday in a major day. And so the sweater vest was red on Saturdays because Tiger wears red on Sunday for the final round of a major. So, and then the first time we won, then the students then won't let me do anything different. So we won in 2011 and I'm wearing the red sweater vest and I'm telling them why I'm wearing the red sweater vest. So then it's when we even go to White Plains and we're in the hotel, they're asking me if I brought the red sweater vest. And so because the idea that I wouldn't wear it on Saturday would become unthinkable to the students. So the answer to the question that you asked was yes, apparently I did have some superstitions. And, in hindsight, they were fun. But at the time, I was incredibly nervous about it and would go back and forth whether I was looking kind of stupid wearing the red sweater vest, but I can't not wear it because the students will go crazy and that'll throw them off their game. So yes, superstitions were involved. I also wouldn't step on the chalk line between the pitching mound and the dugout because that's bad luck.
That's fun. I knew there had to be something.
Oh yeah.
Hi,
Hey,
Professor.
Allison.
I have a question.
Okay.
Also, hi.
Hi.
Based on what you've been saying about the role of moot court in legal education, both skills-based and substantive education, in what ways do you think that could be incorporated into the broader curriculum, whether that be skills classes or workshops?
Well, and I think it is incorporated into the broader curriculum in skills classes. And, we have a number of skills classes, that are offered. The first years all have to take the contract drafting and negotiation where they work in teams during that process, and they get a lot of, and I teach that contract drafting course. And so they get a lot more feedback from me as they're doing skills type of work during the negotiation part of it, and feedback on their drafting part of it. And that is more enhanced than what happens in the traditional big classroom where I'm teaching contracts to a fifth of the first year class, or property to half of the first year class, where that just can't happen. And also we have such incredibly robust clinic experiences now. And I know that they do a lot of things during those sorts of programs that approximate the sort of things that can be happening in moot court. But even with clinics, though, it's somewhat constrained by those are real cases. And so one of the things that makes moot court so great is it's all pretend, it's not real. Because the idea of spending hundreds of hours on a single case because you're insanely crazy and you're really trying to win a moot court competition, you're not really representing a client, well, you couldn't do that in the real world. You wouldn't be able to do that, in real life situations, because it would just increase the costs of it to a level that are just intolerable. And again, which to me is the advantage of moot court, because it's pretend. So no one's actually having to pay this cost other than the students who are doing it are paying the cost in a major way. I was paying the cost, of course, but I'm volunteering for it, just like the students are volunteering for this. I'm doing this because I see you, Caroline. So, but there is a way that it can get more into the basic curriculum, and a lot of professors will incorporate that into their, I know Ferris Percy, Professor Percy in her civil procedure classes, Professor Hensley in her property class. They're doing some things like this that I think are useful. It's just that you can't do it at the same level. You can't do it at the same intensity because you're doing other things as well. But it's, I've said this to deans, I've said this to students on different times. I wish every single student who graduated from Ole Miss Law could have this experience that I'm describing, that they could have come through and been a student on one of these teams that are competing in this competition before they graduated. Because every single student that, maybe a little too much, virtually all of the students that I worked with over the years, both at Memphis and at Ole Miss in this, said to me that this was the best educational experience they had in law school. And I knew they weren't lying to me because I was there and saw it and convinced, just like they were convinced that that was true. So it's the kind of experience that would be great if every student could get that, as part of their law school experience before they graduate. I don't know that that would be possible, though, because you would have to have faculty or lawyers, that would be willing to do that and donate that time. My article is about trying to convince, full-time faculty, tenured faculty to do this. And that can be a hard sell. I was willing to do it, again, because I'm a little bit crazy, maybe a little bit, dishonest. And so once I got hooked on the competition part of this, I do what I do, and I pointed my obsession at this. And so I dove in and was willing to do this. It's a hard sell for professors who are very, very busy with whatever it is they do, however it is they do it. But it would be wonderful if we could have every law student receive this kind of an experience before they graduate. But I don't know how we pay for that, and I don't know how we staff it, because even I have decided to retire from it. Because I finally made the personal choice that, 2 decades was, I thought enough. But anyway, I think I'm now rambling a little bit in response to your question, which is an excellent question, that if we could get more students this kind of an experience, because of the fact, again, circling back to, because it's not real. I mean, it's a problem-based approach to learning where, hey, you're taking on this problem and now it belongs to you and you've got to argue the case. So you've got to prepare yourself to argue the case. And the incentive is, well, I want to win at that. And so I'm going to really get into it. I'm really going to work hard at this preparation to argue the case. But it's a comprehensive experience that touches on all aspects of lawyering, both procedural and skills and substantive. And so it's really a deep, immersive educational experience that you can put as much time into it as you want, because it's fake, it's not real. But the competition aspect of it is what convinces students and faculty to take it seriously. It may be fake, but it's not really fake because the competition part's real. And so that's, I think, what makes this, it creates the opportunity for the educational experience to be so good. And again, I don't know how you reproduce that at that level in other aspects of law school life.
Okay, we are coming up on our time, and I'll end it with one more question, Professor Case. The world's different now than it was a year ago. It's evidence that you're sitting at your house, I'm sitting in my house, and we're at work. How has this changed the Moot Court program and negotiation board? How have those programs changed based on a lot of the world being virtual now?
Well, I can't speak to that, but I can speak to the PACE competition. Because I'm in touch with the folks up there a lot, because over 20 years, I made a whole lot of friends at Pace Law School, but also all across the country, law professors and lawyers that coach teams. And so I kind of stay in touch with that network. And the PACE competition has had to go virtual, because they're trying to talk me into being a judge, which I've done that a couple of times over the years. I've actually judged at the PACE competition on either year that I didn't have a team. My first year at Ole Miss, when I came from Memphis, I tried to get a team together to take to PACE that year, but I made the mistake of explaining to the students exactly what the process was. And the Ole Miss students that year, this would have been the fall of 2007, the ones that I could convince to talk to me looked at me like I was a lunatic. And they said, "You want us to do what? Are you crazy?" I said, "Well, yeah, a little, but we're trying to win. And to win, this is what you have to do." And so I couldn't convince a team to go. So I went that year as a judge. And they want me to judge this year at the competition, but it's going to be completely virtual. And so that means that the teams will be wherever they are. It'll certainly cut down on the expense of the competition, as Ben was talking about. If there's no travel, no airfare and no hotel expense. But the judges will be, virtual. The teams will be virtual, and everybody will be doing it on Zoom. Now, we recently had a gathering of, I clerked on the Fifth Circuit for Judge Race of Archdale, and we had a gathering of former clerks pretty recently. This is the judge's 30th anniversary on the bench. And the judge tells me that that's exactly what's happening in real practice, that all the appellate argument going on in the Fifth Circuit is happening virtually. The judge doesn't leave his chambers in Jackson for sittings in New Orleans now. He's doing it over Zoom. So the lawyers are, operating virtually. The judges are operating virtually. Courts are operating virtually this way. That's what's happened to the competitions, I expect, because I know it's happened to PACE. So one of the great parts of the experience was actually going to White Plains and being there with 75 other law schools, because you got to interact with and meet other law students from all over the country, other faculty and professors. Attorneys would come from all over to be judges. So it was a wonderful experience to all be in one place, and the opportunity to get to know and network and all the wonderful things that come with that. And that's lost right now because of the pandemic. But the actual events themselves seem to be still happening, but modified for our virtual reality, which, I'm not having a good time. I'll just say individually, I'm not enjoying this, even though I'm still able to do my job. I still teach my courses. I am still able to deliver the content the way that I deliver the content. It's just that I'm sitting in this room in my house and have been since March. And I'd rather go to the law school building. I'd rather go to White Plains for the competition, but so I assume that's having a big effect, that for all the advocacy boards, but I don't know specifically at what level they are modifying what they normally do. I think they're taking hybrid approaches in some ways, because I noticed, for example, the trial board was doing a competition at the law school building, and they're using the courtroom. So some of what's happening is virtual, some of what's happening is happening in the courtroom, but everybody's masked up and social distance and everything else. So it's got to be quite the challenge. And I can't help but think it, diminishes some of the value of it, some of the enjoyment of the experience, to say the least.
Okay, thank you so much for joining us today, everyone. And before we sign off, these upfront series are going throughout the year, and I expect that we'll pick back up. The law school has committed to doing one of these every month. Next month, we've got a real treat. Professor Chris Green is going to be talking about the very recent role, actually direct role that the university, that our law school played in the vetting process for then nominee Amy Coney Barrett to the U.S. Supreme Court. So my understanding, it was a completely nonpartisan panel that goes in and does this vetting process. And I'm probably butchering exactly what they did, but Professor Green on November the 20th will be joining us. I think it'll be another 11 a.m. Central time slot for that. Promotion hasn't gone out yet. We wanted to get Professor Case here and have him. We didn't want to conflict our promotions on our law professors. So
I was involved in the thing with Chris Green too.
It wasn't just Professor Green; it was several people on the our faculty. So
Chris gets most of the credit, though. He did lead the charge, but it was a really great thing for the law school to be able to be a part of. So.
Absolutely, it's a very great national prominence that we were able to place a role in that. So thank you everyone for joining us. Professor Case especially, thank you for your time. This is, we don't pay him to do this. He volunteered. I've unleashed Stacy Lantane on him, and she's able to get all of our professors to join us to do these events. And it's helped us keep our alumni engaged when we cannot get on the road to see you face to face. So thank you all for joining us. And thank you, Professor Case, for providing this engagement opportunity.
Thank you, Scott.
With that said, this has been recorded. We will archive it on the Ole Miss alumni webpage if you want to come back and see it later. And I can send a link once it's ready as well to send to all of you if you want to see that. I'll email that out to everyone. Thanks, everyone. Have a great weekend. Happy Halloween. And we will see you guys hopefully in person sometime soon.